Welcome to the Real Estate Syndication Show. Whether you are a seasoned investor or building a new real estate business, this is the show for you. Whitney Sewell talks to top experts in the business. Our goal is to help you master real estate syndication. And now your host, Whitney Sewell.
Technology is creating opportunities in the commercial real estate industry at an increasingly rapid pace. Technology-fueled innovations are enabling those forward-thinking firms to reduce back-office costs and risk, raise equity faster, and increase asset performance so that they can focus more time on activities that drive revenue. Today, IMS is the most widely adopted investor management software for commercial real estate firms. Visit us at investormanagementservices.com.
This is your daily real estate syndication show. I'm your host, Whitney Sewell. Today, our guest is Amy Wan. Thanks for being on the show again, Amy.
Thanks for having me back.
You know, Amy's doing a series with me, going through different parts of the legal process and structuring and all kinds of things about that we need to know as syndicators. And I really appreciate her time. And you know, she is the founder and CEO of Bootstrap Legal. She's authored LexisNexis Private Equity Practice Guide. She was named one of 10 women to watch in legal technology by the American Bar Association Journal in 2014. And anyway, we're thankful to have you here, Amy. And today we're going to specifically focus on the just real estate syndication legal structuring. Correct?
Yep.
Yeah, this is a topic that people ask about all the time, or want me to ask an attorney when I have them back on. So this is great. Everybody wonders, you know, how should I structure this complicated thing that we're trying to put together, you know? And I appreciate you explaining this. So get us started.
Sure, of course. All right. So maybe the first thing to do is we want to define a few terms and, you know, dispel a few myths. So, you know, I think there is a lot of talk around GPLPs versus LLCs, and really they're very similar, but they're slightly different, right? Everyone thinks that when they're going and doing a real estate syndication that it's automatically going to be a GPLP structure, but that's not always the case. Here's the difference, right? I think that when it comes to folks who are better off with a GPLP, they tend to be people who they're not beginning real estate syndicators. They are experienced syndicators who are doing this full time and have a full-time team, right? So you know, you have a team of maybe 5, 10, 15 people. Maybe you've got a handful of principals, right? Versus folks who are using more of an LLC structure. Even if they are doing this full time, they don't have a full-on team, and there tend to be not nearly as many principals. Why? Because this all goes back to succession, right? So the question is, what happens when, you know, like you're a real estate syndicator, you get on a plane to go see your next project, and the plane goes down? What happens with all your other projects? Your investors are going to be in a state of panic, right? If you are using an LLC structure, that structure tends to be a lot more flexible, right? So if you look at, you know, the standard voting guidelines and the way the operating agreement is set up and everything like that, basically, it allows a lot more flexibility for someone else to come in and basically run the project if something ever happens to the syndicator. Now, there is a chance that the reverse could happen, that the syndicator is still around and the investors are all just super unhappy. And so the investors, you know, basically vote the sponsor out and try to take the project over themselves, or they try to find someone else to manage it or something like that in case, you know, the thing is going sideways. But, you know, so long as you're keeping your investors happy and you're communicating with them and keeping them well informed, that's a pretty rare occurrence. Now, for the GPLP structure, it is not nearly as flexible, right? So much more rigid. So the reason why you want, you know, oftentimes a full-time staff and many more principals, is that really there's only a set number of people who can take over in case something happens to, one of the principals, right? It's going to be the other principals are going to step in or something like that. Maybe folks on the staff will step up or something like that. But it's not going to be a situation where you're going to have a whole lot of options, right? And so you really want, a much more professional, robust succession plan in place to the extent you're using the GPLP structure. The next thing I want to cover is, one question I always get is, how many entities do I need, right? And it really depends on what are you doing, right? Every project is different.
Could I go back to the first thing just for a minute?
Yeah.
The GPLP structure versus LLCs. I hear it like at every conference, we go to, it's especially people trying to get in, to the business. They're like, well, I don't want to have to do the syndication thing. I don't want to have to pay all the attorney fees. And so, I try to ask, well, what role do all the other people play? Are they just giving you money?
Well, in the two, it's almost practically the same thing. Just because you're doing a GPLP structure does not mean you're not syndicating and you don't need legal documents, right? We talked about this in a previous show. So long as you take one non-accredited investor, you are required to have documents. The rest of the time, it is highly recommended you have the documents, right? In terms of, when are you doing a syndication? Or when are you selling a security? That, so I'm going to tell you a quick story, right? Once upon a time, a couple of decades ago, there was this orange farmer in Florida, right? And he thought he was going to be really clever and basically pick on tourists that were coming through that part of Florida and sell them lease back. He was going to sell them the land that all the orange trees were on, and then he was going to lease it back so that he could actually farm on the land. The SEC got wind of this. They were not incredibly happy, and so this is all a real story, by the way. That is how the Howey Test came about. So the guy who actually did this, his name was Howey, and so there actually is it's like, a very basic test that tells you whether or not something is actually a security, right? Okay, so the Howey test is a 4-pronged test, and basically it defines whether or not something is a security. Anytime you're selling a security, all the securities laws applies. Doesn't matter if you're doing a GPLP structure, doesn't matter if you're doing an LLC structure. This does matter in terms of classifying whether or not it's a JV or not a JV, which people also get confused about. And I think we talked about this on the first show, but I'll come back to that in a second. So the Howey test is basically this. It's 1, an investment of money. 2, there's an expectation of profits. 3, there's a common enterprise. And 4, it depends solely on the efforts of a promoter or third party. Okay, so in your average real estate syndication or GPLP thing, right? Investors are investing money. They're expecting to get a profit. The common enterprise, that just, there's different ways that test is interpreted, but basically, this is all a common thing. It's not like, oh, this person's doing this person's doing that, right? It's all a common project. And then 4, which is the most important part, is it depends solely on the efforts of a third party, right? So in a GPLP structure, you have some silent investors, and then you have the actual sponsors, the GPs, right? So long as you have passive silent investors, that's still going to count as a security. So I hadn't heard what you said before in terms of, GPLPs not requiring or not necessarily being a security.
I think it's just this thought when people are trying to get in the business and trying to keep from having the expense of a syndication, or, or paying those fees to have a PPM and those things. It's like, well, I'll just go over here and have an LLC and, kind of joint venture thing. And I'll have investors, but, they feel like they're not selling a security. So.
Yeah. So let's talk about JVs real quick. And we did talk about this on the first time I was on your show, but basically a lot of people think, oh, well, I'm gonna structure it as a JV because then I don't have to do all this real estate syndication paperwork, even though there's still paperwork involved. And the thing is, if you go to a regular real estate attorney or regular corporate attorney who does not know securities laws, right, they're not going to know either. So really, you have to be approaching a securities attorney to figure out whether or not this is a security. But basically, a JV is more so a situation where the folks who are putting money in are not silent investors, they're not passive investors. They are part of the sponsor team, right? So they're not actually going out and raising capital. The moment you go out and raise capital from 2 or more passive investors, that's a security. There's no other way to slice or dice it. I'm sorry. And the attorneys that say otherwise, it's because they don't know securities law usually. Yeah. So, I hope we've clarified that.
Yeah.
I know a lot of people, will still go out and do the JVs, but it's just, it's really risky, right? And at the end of the day, a lot of people are like, well, when do I really need, when should I have the paperwork versus when do I not have to have it? Like, again, one non-accredited investor, you have to have the paperwork. Every other time, it is optional but highly recommended. And basically, I tell clients that this comes down to your own risk tolerance, right? I find that people who are like in their 20s and they think they're invincible and they're like, nothing's going to go wrong, right? They they have a much higher level of risk tolerance. People who are in their 40s and they have kids and they're like, I cannot go to jail because I have to provide for my kids. They will sit down there and they will do the paperwork, and not just the kids. It's also because they've had deals go bad previously, and they've seen what it's like to not have everything clarified in writing. Right? It tends to get a lot more messy.
Yeah, no, I appreciate you laying that out. Like, what is a security, and laying out those 4 things. And I think depends solely on the efforts of the third party. Like you said, the most important part. And I think that one alone would clarify it for most people. They understand they're doing all the work and they're, somebody's investing passively, but we better keep going about how many entities and the roles of each entity. Okay.
So, in terms of how many entities you need, it depends on what you're doing, right? So at the very, very basic level, most syndications have a minimum of 2 LLCs. So one is the LLC where, it's the actual investment company where it holds the property and investors are investing into that LLC, right? And in that way, in a sense, they are directly secured. The other LLC is a manager LLC, right? And that's where the sponsor lives. And the manager owns a portion of the actual investment LLC, okay? So that's your most basic. Some people, when they do this, for various reasons, they want to use 3 LLCs, right? And the extra LLC is just an LLC in the middle. Sometimes it's for banking account purposes, like they don't want the property manager to see how much is actually in the bank account of the investment. And so investors will be invested into one. The property is held in another, and it's wholly owned by the investment company one, but all the investment funds are there, and then it's slowly deployed down to the other LLC where the property manager, may have access to the bank accounts to get bills paid, things of that sort. And then you've still got the manager LLC. Now, to the extent that there's more than one property, I always say that it's wise to put each property in its own LLC, because what happens is if there is like a slip and fall case on property one, you do not, the people who are suing you, you don't want them to recover against the assets of property two, right? So you're segregating all that liability, okay? Now, I think maybe it also makes sense to clarify the different types of real estate syndication that there are, because that means that there's also different strategies, right? So the three basic types are single asset syndication, and that is where you are syndicating or you're raising capital for one property specifically. You probably have that property under contract, so it's very easy for you to identify, right? A semi-specified fund is where you might have two or more properties. Maybe you have identified one, but maybe you haven't identified the others, right? And so it's a multi-property fund where your investor knows at least one of the properties, but they're going to trust you on the other ones, okay? And the last one is the blind pool, right? And that's really where you don't have any properties identified. The investor is basically investing into a fund that will then deploy funds as the manager sees fit. And so, the reason this is important, for legal reasons, like the language will change, but the reason this is important is because at the end of the day, and I think this is a theme on every single episode I've talked about so far, it's all about trust, right? When you are raising capital for a single asset syndication, the investor is able to do two types of due diligence. They can do due diligence on the property and make sure it's something that they want to invest in. And then two, they do due diligence on you, the sponsor. So it's two levels that you have to get through, but it helps them really understand what they're investing in and really trust you. For a semi-specified fund, right, they're due diligencing you, and they can do due diligence to one of the properties. And then for the other ones, you give them this general plan of what it'll probably look like, a multifamily building in Connecticut or whatever, right? Blind pool, suddenly it's harder to trust because you can only due diligence the sponsor and their track record. And the sponsor is going to lay out for you a general business plan of, I am going to acquire multifamilies in tertiary markets across the United States. And they're all going to be in the X million dollar range, blah, 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 right?
You're really going to have some trust from your investors to do a blind pool, right?
Exactly. And so when I'm actually talking to clients and trying to help them figure out a strategy about how to structure this is basically what it comes down to. It comes down to cost, and it comes down to your investor base, right? Because people say like, how do I structure this? Well, what is your investor's appetite? You have to understand your investors. Like friends and family, they will readily invest in a blind pool. If you are a large marketer or an influencer and you have that following, they will probably invest in a blind pool. If you are dealing with sophisticated credit investors and you don't have much of a track record yet, it's going to be very difficult for them to invest in a blind pool. They're going to want to invest property by property, right? So it depends. The other thing I'll say is folks who are doing much smaller pieces of real estate, flippers, or people who are like, doing single family houses or maybe 4-unit buildings. The reason why sometimes they will bundle everything into a pool as opposed to single asset syndication is because the raise is often very small, right? Like think about it, like a house in the Midwest might be like $100,000, right? If you get financing on it, suddenly you only need to raise maybe like 20,000, right? It's not worth it to pay, whatever the fees are for legal for to go raise $20,000. But if you can bundle 10 properties in there and make it a $400,000 offering, then you save money on the legal costs and you pass that off to investors because ultimately they reimburse you for it, right? Otherwise, it cuts too much into their distribution. So that's why folks who are working often on the tiny raises will do a fund.
Oh, that makes sense. I've heard of people recently doing blind pools, but they are very experienced operators. They've done 20 syndications or more. Right. And it's very interesting because, and I always tell clients this, you have to know your investor, right? Because they'll ask me like, oh, I always do single asset syndications, but I want to see if I can just have the money up front and then deploy it. And I always say, well, have you polled your investors or sent them a survey asking if they'd be willing to invest in this? And sometimes, what I'll have is, I've had clients who they will test it out with a specified fund, or they'll instead of doing the survey route, they'll do a little side fund and say, oh, you have diversified access to all my deals, right? Sometimes it works, and sometimes they get a lot of backlash from their investors. Oftentimes, I don't see blind pool and single asset syndication investors being the same profile investors. They tend to be different people, right? So you want to keep all that in mind. It's just like if you're running a business, right? Like you have to know your customer here, know your investor, know what they're going to be willing to invest in. And it's okay to ask them, right? That otherwise, you don't want to spend like $7,000, $10,000, $15,000 on legal and then find out. That's a very expensive survey. No, I appreciate you just laying that out too. Like doing a survey. Just somebody suggesting doing a survey so you understand your investor base better.
Yeah. And actually, if I can just give a quick tip, this is actually the same thing for distributions. A lot of first-time syndicators say, hey, like, what's standard distribution for one of these syndications? So first of all, it depends on what are the risks, right? Are you working with raw land, or are you just improving existing multifamily, right? The standard is like a 70-30 split. It can go down to 50-50. I've seen 80-20, right? If there is a preferred return, it's anywhere from 8 to 9% preferred return. But after that, people can do whatever they want. I have some clients who do like triple waterfalls and stuff like that, right? And it gets really crazy. But at the end of the day, the answer is, how should I structure the distribution? It is, half of it is what is market. The other half is, what are your investors willing to accept? Because that's the only thing that matters at the end of the day. If it's too low and your investors won't buy it, then they're not going to buy it, right? What I do tend to see is more experienced syndicators, because they have a large pool of accredited investors, they can be more commanding. So they can charge more in fees. They don't have to give out nearly as great distributions versus first-time syndicators. In order to get people through the door, they are much more willing, especially for their first deal, to give up almost everything just so they can start building that track record. I have one client, I think they had like a 16% preferred return, right? Because it was new construction.
Wow.
they didn't know anyone. It was their first deal. And they were like, I want to treat my first investors right, because I'm just trying to make this happen. Like, I don't want to fail. And they didn't fail. And now this person's, like 5 projects in.
Nice. I appreciate you sharing that story. That's good to know. And I hear that often too. Like, to do my first deal, I'm willing to not make anything.
Yeah.
So, yeah. I mean, knowing how to structure that so our investors are happy and they're ready to see the next deal.
Yeah, definitely. Definitely.
So any other, tips for the clean practices or, making this happen as smooth as possible?
Yeah. So, you do not want to run this business willy-nilly, right? You want to operate all the banking accounts properly, right? You should actually, so there's a term in securities law called commingling of funds. Never commingle funds. Do not mix your personal and your business accounts. Don't mix the accounts of like the manager with the investment property. Don't mix the accounts of your first offering with your third offering. Just don't do it, right? And it sounds very obvious and very like duh, right? But I actually had a call 2 weeks ago from one of my clients who's an experienced syndicator now, but they're like, hey, I have largely the same investors in this offering as this other offering, and the investors are getting antsy because this one we're having issues exiting, they haven't been paid out yet, and this one, like, it's exiting basically in a couple weeks. Can I funnel some money from one to the other to, like, pay them early for the distributions, whatever? I was like, no, like, it doesn't matter if they are almost the same investors. You just want to operate everything super cleanly and by the books. And, the other thing is your investor will appreciate that too, right? If you do it once for them, they might tell another investor and another investor might demand it, right? I think your investor would appreciate a lot more if you say, look, we can't do this.
Right.
It's called commingling of funds. Legally, we're not allowed to do it. And if I did it for you, that means I would do it for others too. And next thing you know, you have like a Bernie Madoff, like Ponzi scheme thing going on where it's like, oh, I'm taking money from one to plug the other. Like, you just don't want to do it. The other thing I'll say is make sure you follow all securities laws. And this is really on your attorney to counsel you through that, but it's also on you to ask your attorney all these questions, right? If in doubt, just send them a quick email, text, call, do a quick gut check, because at the end of the day, if you are found to violate securities laws, depending on how gross the violation is, there's something that we call bad actor rules. Bad actors, people who the SEC or states proclaim to be bad actors, they are barred from doing things later on. So one of the things is, if you don't follow securities laws and you are actually caught, right? There's a number of things that can happen. There can be civil penalties. You can go into jail. But the one thing I find resonates with syndicators the most is if you are found to be a bad actor, then they can actually bar you from being the director or officer of any company that is raising capital for, 1 year, 5 years, the rest of your life, right? If you are no longer allowed to be a sponsor, and real estate syndication is your business, I'm sorry, like, you got to find in your career, you're done. Like, you will never be able to raise capital again. And I think that's the scariest thing for any entrepreneur.
That's a bad day.
Yeah.
Would you be able to be like on the asset management side of a team? Would you be able to do something else, or is it just like keeping you from raising capital, or maybe being the the lead sponsor?
So it depends on what you negotiate with the SEC enforcement officers. But at the end of the day, even if you can work in a regular employee capacity, when investors do their due diligence, this is depending on the facts and circumstances, it's something that's probably going to want to be disclosed. If that's the fact and your investor sees that in the disclosures, there's
Right.
so many deals out there that they can invest in. Why would they invest in something where someone got in trouble with the SEC, right?
Yeah. So you wouldn't really want that person on your team because of that. I mean, it just gives you all a bad reputation.
Exactly.
Yeah.
Exactly.
Wow. So how often have you seen something like that happen? Or, I mean, is it very often?
So, real estate is one of those industries where there's always a lot of fraud, right?
Mhm.
Not necessarily on the security side, but I'll say this. Actually, real estate malpractice insurance for lawyers is the second most expensive malpractice insurance out there, after patent prosecution. And the reason is because the stakes are so high, right? Securities, when you're raising capital and selling securities, it's a serious thing, right? You are doing things with, sometimes it's people's life savings. So the government does take this very, very seriously.
Good, as they should. Anything else, Amy, as far as the structuring of these deals and syndications that we should hit on before we have to end this show?
I think that's pretty much it. But if folks have any questions, they're always, they should always feel free to reach out.
Okay, and they should reach out to you where?
Yeah, sure. So my my Twitter and my LinkedIn is Amy Y1 WAN, and they can always go to bootstraplegal.com and request a free consultation.
Great. Thank you again, Amy. I really appreciate it. I'm grateful for all your time and explaining just many aspects of this business on the legal side, which is very daunting. And for most people that aren't into the business or looking to get in, that's very intimidating. So I appreciate that. But I hope the listeners will contact Amy. I hope you also go to LifeBridge Capital and connect with me and go to our Facebook group so we can all learn from these experts like Amy together and grow our business. And I will talk to each of you tomorrow.
Thank you for listening to the Real Estate Syndication Show, brought to you by LifeBridge Capital. LifeBridge Capital works with investors nationwide to invest in real estate, while also donating 50% of its profits to assist parents who are committing to adoption. LifeBridge Capital, making a difference, one investor and one child at a time. Connect online at www.lifebridgecapital.com for free material and videos to further your success.